Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Govea. I am a criminal defense attorney broadcasting from the Valley of the Sun deep in downtown Phoenix, Arizona. Today, we're talking about instructions. Some of these instructions are, kind of boring a little bit, maybe you might think. I don't think so. But we're talking about jury instructions, very important, the critical part of a case. We have a lot of evidence that we have been following in Proud Boy's trial day 60. We thought we were going to get to closing arguments today. The answer is no, but we are going to go through jury instructions and some other closing items that took place at the close of trial. It's Friday. Closing arguments are going to start next week on Monday. And so we're going to go through all of the trial proceedings for Proud Boy's trial day 60. But there were some other instructions that were being sent out. And some of those instructions, some people are saying, may have gone over to Ray Epps or other people investigating Ray Epps or other people prosecuting Ray Epps to not prosecute him. But something interesting has happened. Ray Epps, even though we haven't been able to follow him, has suddenly sat down with 60 Minutes. And they're going to be releasing a full interview on that on Sunday with our pal Ray Epps hanging out with the 60 Minutes crew, talking about Lord knows what. We're going to break this down because Ray Epps made several additional appearances here on the January 6th Fedsurrection Day. And we've got Ray Epps right there. We're going to go through some of this new footage that came out in the Proud Boys trial, and then Julie Kelly assembled it. And it looks like to me, I don't know what you guys think about this, but look at that. That's an assault right there. Look at that. He makes physical contact with that officer, it looks like. And he's telling him, stop. Violent behavior certainly should be prosecuted or if the others are being prosecuted, why wouldn't he be prosecuted? But there's questions about whether Ray Epps is going to be filing a lawsuit against people like Darren J. Beatty over at Revolver News. And we're going to do a refresher on some of the reasons why the questions around Ray Epps are not conspiracy theories. In fact, they're pretty well rooted in fact. So we'll go through some of these highlights in a minute. But of course, my friends, we also have some motions to strike from the defense that I want to go through. Carmen Hernandez, on behalf of Zachary Real, submitted two motions, one yesterday and one today. And these are addressing those last minute disclosures, these things that just sort of popped up out of nowhere about the pepper spray with Zachary Real and some other allegations that the government just dropped at the last minute. And so the defense is responding to that. And we'll also, as I said, talk about jury instructions. And so, as you can see, we've got a lot to get to today. And if you want to be a part of the show, we have an amazing community and our friends over on our memberships, whether you're at watchingthewatchers.locals.com or if you are joining us on YouTube. We just had some amazing new gifts come in from our friend Dolphin Fan and Voice of the People. So we've got 10 new members courtesy of Dolphin Fan and Voice of the People. And we just have a ton of new members. Our morning streams are a lot of fun. It's a little bit more casual. Some of the segments that you might see on YouTube or on Rumble, we record those in the morning and, we kind of, have fun while we're doing it. And so we like to have a little casual stream, and then some of that stuff shows up on YouTube. Most of it does not. And so it's mostly member stuff. Come check us out either on YouTube or on Locals, watchingthewatchers.locals.com. We've got new members, Dustin, Johnny Boy. Hey, Johnny Boy. We got Gwennick, we got Annette, we got Daniela. Voice of the People's bringing in Alan, Tammy, JC, Starlet, and Scooby Fish. We're so grateful for you guys. Thank you for inviting them over. And if you're a member, don't forget to grab our private Telegram link, which is where the chat continues on even after this show is over. It's a great way to stay connected, stay plugged in, and chat after the streams are over. Now, we have to be properly nutrified before we go into today's program. It is Friday. It's time to make sure that we have our nutrition situated, before we go into this weekend. I don't know what your schedule has on store for it, but I've got probably pizza and burgers and other things. So it's got to have to come after nutrition, because we all would like to lose those leftover pandemic pounds. And we're all sick of the weight loss and the fad loss pills, diets, all the books, all the things. We've all been there. We've all done that. And we know that they just don't work. But you know what does? Eating 5 servings of healthy fruits and vegetables every day. You do that, and the weight would probably just fall right off. But look, vegetables, not a fan. And who's got time to prepare fruit every day? You don't have to worry about it. Instead, let's talk about Field of Greens. Now, we know Field of Greens is a science-backed formula, very specific fruits and vegetables that you're not going to find in any other product. Proper nutrition reboots your metabolism so you can burn calories faster and lose weight the healthier way. And Field of Greens is the only brand backed by a better health promise. Yes, you're going to look healthier and feel healthier fast, but the greater proof is going to come at your next doctor's visit when he looks at you and says, wow, whatever you're doing, keep it up. And so let's get you started. Go on over to fieldofgreens.com, get your real organic superfood. Don't forget to use code Robert when you check out. You'll save 15%. They've got a ton of other stuff for weight. They've got stuff for joints. They've got stuff for sleep. And of course, they've got Field of Greens. So you'll be bursting with green energy and feeling good all the time, baby. So check it out, fieldofgreens.com. Don't forget to use code Robert when you check out so that they know that we sent you. And you can get your mom some too and tell your mom, eat your vegetables, mom. That's like I'm doing right now, talking to you, mama. Eat those veggies. All right, and so let's get right into it, my friends, because we have some business to attend to. And it comes back to Ray Epps. A lot of questions about Ray Epps. He hasn't really been available for many people to talk to. One group of individuals who would love to sit down with him are the Proud Boys and their defense attorneys who've been trying to subpoena him so that he can come in and testify in one of the most important trials in America taking place right now. But he didn't respond to a subpoena. The judge would not allow the Proud Boys to serve him by publication. And so Ray Epps is still a wanted man, wanted by the Proud Boys, but they have not been able to get him. But somebody is able to sit down with him, and that looks like it is 60 Minutes. In fact, they're sitting down with him on Sunday. Here is what they posted over on Twitter. They said the following: in conservative media, Ray Epps is a notorious villain. I don't know about conservative media. I mean, I guess if that's what you want to call it. I think it's reality media, people who have seen the footage, which we'll get to. They call Ray Epps a notorious villain, responsible for turning the protests on January 6th into a riot. And I take issue with this. We're not saying specifically that Ray Epps, this guy, is responsible for January 6th. Nobody's alleging that. Nobody's saying he is the main orchestrator, the person responsible for tipping the scale on this thing. No, we've got questions about whether he is a part of a much bigger operation, whether he was in cahoots with the feds or DHS or Homeland Security, whatever, any agencies. We would just want to know more details about it. And Ray Epps is really a symbol of a much broader scheme that we'd like to investigate. But 60 Minutes is going to turn this into just a single isolated case of a dogpile of bullying on the internet, taking advantage of conspiratorial nonsense, which is weird because it's funny. You know, they're talking about here, they say it is a convoluted conspiracy theory he denies. All right, well, I guess we can look at the evidence. There's a lot of other conspiracy charges that a lot of other J6ers deny. In fact, there's a whole trial going on about this right now. The J6 trial that's taking place is about a conspiracy, a seditious conspiracy, in fact, alleging that 5 Proud Boys were responsible for it. You know what? They all deny it, and there's a ton of evidence to support their denial, but they're still being prosecuted. So why does a denial matter in any way, shape, or form? Who gives a crap what a denial is? A lot of other people denied their conspiracy, and they are charged, and they've been in custody. Some of them housed for 23 hours a day in solitary. Now, Ray Epps is in hiding. He's facing death threats, and we don't ever condone death threats or violence here, ever. But this hiding thing is curious because people do want to hear from him, including by legal process. But he's not sitting down and communicating with them. He's only communicating with what I would guess is friendly media called 60 Minutes, which is going to continue to promulgate this propaganda and shove it down our gullets. Now, I wanted to pause on this section right here. You see this Revolver piece? Why are they bringing that out? Revolver put together a brilliant summation of all the reasons why Ray Epps is a questionable figure in this saga. And they also included Tucker in this little montage here. And in this montage, we know Tucker has already been threatened with litigation by Ray Epps and his lawyers. The question was, is Revolver News also going to be threatened? Because they put together this beautiful, brilliant piece, which if you haven't read it yet, it's basically the de facto piece on all of the problems with the Ray Epps story. So he is here now saying it's a giant conspiracy theory, and the full interview will be out there on 60 Minutes. Wild that they talk about a conspiracy theory where they're playing clips with him. Literally there on January 6th. He's standing there. He's there on January 6th. Now, why did they pick these videos? They could have picked the other videos where he was whispering to Ryan Samsel at the first breach. They could have picked other videos like the one I'm about to show you to talk about their conspiracy theory, but they didn't do that at all. So we'll see what kind of garbage comes out on 60 Minutes when they actually air that. Darren J. Beatty says that if they dare decide to sue Revolver News, I assure you of this, we are not going to settle. So shout out to Darren J. Beatty. If you're not already following them over there, you certainly should. Darren at Darren J. Beatty, because this may be heating up. And Cernovich had another great tweet on this. Cernovich said that inclusion was just a shot across the bow, right? This was the weaponized media government conglomerate declaring war on Darren J. Beatty for daring to question their fictional narrative that they have been trying to cram down everybody's throat. So that is what we saw from 60 Minutes. We'll be very curious to see what that interview looks like. As we've been covering the Proud Boys trial, we know there have been a lot of different videos that have been released, and we have a nice summation of some of these videos from Julie Kelly, who, as we've explained here, is a great follow and somebody who's been on the top of really the J6 cases for a long time. And I want to go through a couple of these. I'm going to keep the audio off just for our censors out there. But Julie Kelly posted this yesterday after the trial proceedings and said, here you go. Check this out. New body-worn camera footage aired in the Proud Boys trial shows not just another assault by stormtrooper DC police, which they were very aggressive in a manner that was not the same as other protests in other places around this country. And some people, according to Dominic Pizzola's testimony, which he told the jurors, the crowd was actually pretty dang peaceful until they started lobbing projectiles and stinger bombs into the crowd. So here you see, here's another camera, but it's not even that violent yet. But here, guess who this is right here? It's Ray Epps. Look at that person standing right there. And here he is showing that he is urging the police to calm down. Right? See, he's right there at the front entrance. And so there's Ray, and there are a bunch of other people there. And because we don't have all of this footage and we haven't been able to assemble all of it, are these all Trumpers? Are these all Trumpers or all these? Is there any Antifa in here? Was there an investigation by the Metro PD, by the DC police, by the U.S. Attorney's Office, anybody at the DOJ, FBI, DHS to go and really flesh out who all of these people are? Because we know a bunch of people on the FBI's most wanted J6 list have not been picked up, including Ray Epps. So we have questions. If there are prosecutorial decisions of discretion and a prosecutor gets to exercise discretion, we have questions about what those checkboxes are that determine whether a person is charged or not. We're looking at Ray Epps. He was there. He was touching other police, talking to other police. You can see him here. And as there are some bumps and the crowd starts to bump into each other, like they're all standing around here. Watch what happens. This guy's getting pushed in, and an officer is going to come up pretty close. And then Ray Epps is going to reach his arm out and tell, and look, this guy's saying, look, I'm not doing anything, man. I'm just standing right here. Standing right here. They're all just standing around. Doesn't look like cops have started lobbing projectiles into the crowd yet. But Ray Epps is then going to put his arm around this person and say, look, man, pull him back and watch these cops come in. Hey, blocks the cops off. You see that hand right there? He just blocked that cop right off there. Look at that hand. He's telling him, get back. And what? Look, he's blocking the cops off. Hey, get out of here. See that hand right there? And he's like even waving the cops off. Wow, that's pretty much contact right there. Wow, that's a violent assault right there. That's obstruction of justice, clearly. Cops are in there and Ray Epps is interfering. Wow. So we add that to all of the other things that we have questioned about this entire charade. And Ray Epps is in that footage. You see here, here's a close-up of the hand. Stop, stop, stop. He's saying, stop, 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 telling the cops. Everywhere we turn, there's Ray Epps. And again, it's not even about Ray Epps per se. He's just a symbol. He is just one person who is been identified. The question is, how many other Ray Epps were there? That's why we keep using it, because he stands out like a sore thumb. It's just him. So yeah, I would actually agree with Ray Epps that I don't think that he was responsible for the whole insurrection, but I do have questions about his involvement and about who he was talking to. And I've got questions about why he is not on trial and why the prosecutorial discretion has left him immune while huge swaths of the other country have been gobbled up without what I consider to be a lack of due process. Very curious. So now, if we zoom out on this, we ask ourselves in summation, who is this guy, Ray Epps? You remember some of the details. He was here the night before January 6th, on January 5th, urging people to go into the Capitol. That's what he's doing right here. Into the Capitol. We go into the Capitol. It's on video, on record. He was also on the most wanted list on the FBI's post that they dropped on this tweet. This was a tweet that they posted. Look down here in the bottom corner. Number 16, Ray Epps. And his hand is reaching over across on Ryan Samsel. So not only did the FBI label him, saying that we wanted information about him, seeking information, violence at the Capitol, United States. So somebody at the FBI's office put him on this list, a violence list, not just like a curious, grandma, like many of the other grandmas they're arresting out there for stupid trespass charges and obstruction charges. This was a violent categorization. Somebody watched footage at the FBI and they made a bunch of decisions. Yeah, that guy's violent. Put him on the list. Yeah, also violent. Put him on the list. Okay, update the list. That guy's been arrested. Okay, update the list. This guy's been arrested. Do we get this violent guy, number 16? No, we still want him. And it was because he was there at the breach. The video is here. Ray Epps is whispering into Ryan Samsel's ear. We've seen that video many times. So if he was at the breach, he was screaming the day before to go into the Capitol. The FBI considered him to be a violent person. We add into that fact that Ray Epps has a history of being an oath keeper. Admittedly, this was a screenshot from an event long time ago here in Arizona. Ray Epps, standing next to Stuart Rhodes, who was prosecuted with the Oath Keepers, met with Enrique Tarrio the days before January 6th. So they were hanging out together a long time ago when they were part of the Oath Keepers, attending similar events. So we go down all of the different indicia. My gosh, he's checking all the boxes. He's also got a history as an Oath Keeper. Well, certainly there must be something that kept him from facing charges, right? For a long time, it was sort of implied that Ray Epps never went into the Capitol. That's a huge myth too. Giant hoax. He acknowledges in his own deposition, he said, at that point, I went in. Originally, he says, I took a couple steps in. The question was, did you follow the crowd did you leave the Capitol? Tell us what happened. Terrible question, because they don't really want an answer. This was the question from the January 6th Select Committee. They asked 3 questions because they don't want an answer. Ray Epps gave him an answer that they didn't want. He says, yeah, I took a couple steps in. Yeah, I just looked around. I was sick. Tear gas, a lot of bad stuff. But I heard somebody screaming for a medic. So at that point, I went in. I went up where I found an individual. He was lifeless. I knelt down. He wasn't beating. Another medic showed up. And then we started getting ready to do CPR, right, is what he said. So I went in to save a bunch of people, is why he says. And you go through the rest of it. And he was in the Capitol along with everybody else. And other people were saying they were there for similar reasons. They were there to go stop the destruction. They were there to help the cops. They were there to protect the building. Other people were making those same claims, but they got prosecuted, and Ray Epps didn't. Very strange. Very, very strange. So this is what the summation is on Ray Epps, but he's still not been prosecuted, and he's going to come out and call us all conspiracy theorists for looking at the evidence and asking questions. Of course, nonsense, but we'll see what he says, and then we'll pick back up on that next week after the interview. But turning our attention over to the Proud Boys trial, the defense filed a motion to strike because some of the evidence is not appropriate. And I want to run through a couple of these here. This was filed yesterday. And for context, remember, we're in the middle of the Proud Boys trial right now. We are going to be getting to closing arguments on Monday. We've got questions about Ray Epps. Those videos that I just showed you from Ray Epps came out in this trial. Many of those videos were related to new evidence that came out by the government saying that Zachary Real, the person who's drafting this motion, had a pepper spray in his hand or mace or something, and he was spraying officers in the face during this ordeal. Now, Zach, this entire time in his defense, have argued that he is not violent, or never was violent, and that had nothing, and that he was not that person, and that this was not what the government claims it is. And so, after this testimony came out, during the cross-examination of Zachary Real, we were suspecting that the defense team was blindsided by this. Where did these videos come from that showed this spraying, which we covered earlier this week? And so now we turn around and we see Carmen Hernandez responded. She said, "We, the defense, are asking the court to strike these recent video exhibits that purport to show Zachary Real pepper spraying cops." Ms. Hernandez says, "My client moves this court, pursuant to the rules, the due process clause and the confrontation clause, to strike several government exhibits that were brought out during cross-examination." Why? Well, of course, these materials had not been previously produced in discovery. They came from an unknown source, and they were not properly authenticated. She's talking about specific pieces of evidence, Exhibit 2004. She said on April 17th, earlier this week, after Zach completed his direct examination, which we read through here, the government produced 4 videos and other materials minutes before it began to cross-examine Mr. Real. 2 of the videos were CCTV videos, and 1 was an open source video. The 4th video was a clip of a body-worn camera, presumably the one that we just watched. The court denied counsel's objection that it had not had enough time to review the videos. So on the day of trial, Ms. Hernandez just finishes asking Zachary Real questions. The government says, okay, he talked about a couple things, and we're going to use these videos to contradict his testimony. They show her the videos. She says, where the hell did these come from? I never seen these before in my life. They weren't in discovery. You never notified me about these. If they were in discovery, I would have brought them up. I would have dealt with them. I'd have filed motions and dealt with these things. And they said, well, we're going to use them. And of course, in this courtroom, they have a fight over it. And the judge is like, well, yeah, they can do whatever they want. They're the government, Ms. Hernandez. And she's like, pfft. So she files an objection and she's overruled. She says, well, if they can use them, can I have more time so I can read them? No, of course not. You're the defense. Sit down. Shut up. The government had not previously produced the video, she says, that it used to cross-examine Mr. Real. Never seen it. At the time, the government did not disclose to the court or to counsel that the video had recently been sent to the government by a source. Where did this video come from? Whom the government is yet to identify. Wonder who that was. Probably Ray Epps' cousin. Undersigned counsel was unaware of the provenance of the video. Haven't seen it. The government moved the video into evidence through Mr. Real. The question was, off to the left, Zach, do you see the same TV tower that we're talking about? Yeah. And that also appears to be from January 6th? Yeah. And you'd say this fairly and accurately depicts how the crowd looked, right? How the stage looked and how the tower looked. And he says, yeah, you could say that. You can see the prosecutors laying foundation here. Now, the defense says, in light of the unknown provenance or the integrity of the videos, my client's response to the foundational questions, you could say that, is insufficient, saying he didn't properly agree with the foundation. The questions probed a single reference point in the scene. Mr. Real had no basis to determine whether the video fairly or accurately depicted the entire scene. He's not the videographer. He has no personal knowledge of the scene depicted in the nearly 8-minute video, and he has no knowledge about the video's integrity. And who knows what these prosecutors have done. The video did not indicate the time it was taken. Mr. Real was not the custodian of the video and could not otherwise supply evidence as to the type of camera that was used, its general reliability, the quality of its product, the purpose of its employment, the process by which it was focused, the reliability of the entire system or the video itself. And Real's response also lacked certainty. So you could say that. Notably, the following day, the court questioned the government and asked whether the body-worn camera videos that it sought to introduce is, quote, not something that you just plucked off the web. You guys just download this from some Twitter user? Is this a deep fake? What is it? Where did this come from? Are you guys just rendering insurrections now in your AI systems now after you're done with your Joe Biden clips. Ms. Hernandez says the following day, the government produced an additional clip of a different body-worn camera. Neither of the two body-worn camera clips were previously produced in discovery, so the defense has never even seen it, right? Nor is it clear who did the clipping of the videos for what and for what purpose. One of the clips is particularly unstable at the key moment when the government alleges that Mr. Real pointed the pepper sprayer. Again, the government relied on questions it asked Real to establish the foundation. However, Mr. Real doesn't have the ability to authenticate these clips. And without any indication of the integrity, the chain of custody, where these videos came from, or other authenticating factors, it can't be admitted. Over objection, of course, the court admitted both of them anyways. She says the videos were grainy, they were unclear, and at the critical point, one of the videos was completely unstable. Couldn't even see it. So springing such poor quality videos on Mr. Real at the last moment without any opportunity to inspect or review these things impairs his right to confront the evidence. In conclusion, Ms. Hernandez finishes, she says, neither the open source video nor the clips of the body-worn camera were properly authenticated. Their production for the first time during cross violates the rules, and the body-worn camera were very grainy, unclear, and unstable. And using them against Mr. Real, like the government did, without disclosing their integrity, violates the due process clause. It was unfair, it ambushed Mr. Real, and it provided unsubstantiated innuendo rather than evidence. And so it should be kept out, even under 403, which is if it's more harmful than it is helpful, we keep it out of court. That's the rule. Accordingly, Mr. Real respectfully requests that the court strike the exhibits and testimony. Signed, defense attorney, doing an outstanding job, Ms. Carmen Hernandez, filing motions up to the last minute. And this was a bit of a surprise. And as we were reading through the tweet thread, we were asking ourselves where this came from and how this got admitted. And it's because the government didn't disclose it and the defense had no idea about it. And the judge didn't care and said, well, he talked about it. And so he laid it down and everything just gets admitted that they want to use. So that was Carmen Hernandez motion to strike yesterday. And another one got filed today. On April 21st, she says the following, Your Honor, we want to strike more. A big part of a government exhibit 1001. Now, this is an interesting situation. Apparently, there's a video recording that they played in court, and there's a transcript, or I would call them captions, on the video. You know, here how we do the shorts on this channel, and I always encourage people to, share those with a friend and say, hey, this is a kind of a fun channel, and they can come and watch the show to get a little snippet, see if they like it or hate it, and then stick around. But we print the captions on the video so you can see what it says. And sometimes those are right, and sometimes they're wrong. And sometimes they can be used. We don't do this, but you could see how you could use a transcript to maybe correct a word. Or if there was ambiguity about a word, you could put what the word is. Like if you think that they said the word, or maybe somebody said the word we versus them or something like that, right? What did they say there? And you just put it up there. This is what was said. Oh, well, I guess that's what they said because it's imprinted on the screen. You can see how that might bias a jury. So here they're saying that there is no rule of evidence nor any precedent that supports the government's decision to burn in the captions on their exhibits. And she said, we told the government about this. There's no support for doing that. A prior case makes clear that if a recording is of poor quality and there's a number of voices that are all in the mix, and there is a dispute as to the identity of the speaker and the spoken words, then a transcript raises prejudice. Okay, January 6th was madness. There were people all over the place, right? And Ray Epps was also there, and other Ray Epps analogs. There's a lot of different people shouting things and throwing things, and there's cops and there's protesters and there's rioters and there's just madness. And there's a bunch of things being said and a bunch of noise being made. And so we might disagree about what is actually taking place. if the government burns it into the video, it makes it difficult for the jurors to be presented with that ambiguity. She says that here the recording is of poor quality and there's overlapping voices. Multiple people have been captured, and several of the witnesses testified that they were unable to distinguish any individual voices beyond the chats. Can't make anything out. So the government imprinted the transcript right on the videos so that the jurors couldn't come to their own conclusions. Indeed, the courts generally recognize the prejudice where a transcript of unintelligible tape blurs the difference between the evidence, namely the recording and the transcript. In a case, a limiting instruction doesn't erase the prejudice. You can't just tell the jurors to ignore the captions. A recording submitted has to be authentic. It has to be accurate and trustworthy. And it has to be comprehensible enough for the jury to hear it. So Ms. Hernandez says, accordingly, the court should exclude the recordings here. It's not audible. It's not comprehensible. She says this is supported by the fact that Zachary Real denies even making the statement. Under these circumstances, no transcript should be admitted because there's only two short phrases that are at issue here. And the only purpose of the transcript is giving clarity to that short phrase. And we don't know about the clarity of what that phrase says. And so it's going to prejudice Mr. Real if there's a transcript. She says there are only 5 or 6 words at issue here. And with so few words, there's no reason to put a transcript on the recordings. Here, the jury will be able to listen to and re-listen to the segment as many times as they want. The whole video is only 1 minute and 4 seconds, so there's no need for a transcript. And so certainly no need to imprint the words on the screen. The imprinted words will definitely influence the jury subliminally and directly. They're not going to serve as a valid aid to their fact-finding. They're going to supplant the jury's fact-finding role. And the only way to avoid this danger is to exclude the words altogether. And closing out, she says also, we don't even think the government's version of this is accurate. The exhibit lists the time as 12:53 to 12:55, but the data on the video says it was created at 12:54. So the legend on the exhibit is 1 minute earlier than the date of creation, which is the critical time. The bike racks are set aside at 12:53, more than a full minute before the video is being created. So questions about the footage. Where are they getting this footage? Lastly, the defense does not even agree with the government's view. The words that appear to have been shouted are F that, storm the Capitol. F that versus maybe F them, right? F that, storm the Capitol, or F them, right? We don't know exactly what they're trying to say. But in conclusion, she says, well, accordingly, our client, Mr. Real, respectfully requests the court strike the imprinted words, get rid of those captions from the video, starting at 10 minutes and 5 seconds. Respectfully submitted, yours, Carmen Hernandez, defense attorney for Zachary Real. Submitted in the Proud Boys trial, April 21st, day 60. And so there is a lot more to attend to. Let's see what happened in trial, courtesy of our friend at Roger Parloff. And I'm noticing today Roger's profile feels a little bit extra naked, doesn't it? I think we're missing something right here. All right, well, it is April 21st and day 60. He says that the defendant, Dominic Pozzola, became a different man on cross yesterday, calling him insolent and belligerent and hot-tempered. But he said, all that being said, it's not at all clear that Pozzola committed seditious conspiracy. And there was a little bit of change in Dominic yesterday, of course. He was being cross-examined by the prosecutor, Knierson, and he was very agitated that they were rummaging through his journal. And he called it a phony trial and a corrupt trial. And he said that their evidence is garbage. They were going through social media posts and they were saying, did you re-upvote this Parler post and so on? And so Pozzola was certainly aggressive back with the prosecutors. And I don't know how much that helps him personally. I think that a fair interpretation of his testimony would be that it may have been harmful to his case personally, in that, let's say you just advance this forward and you say that they're going to get convicted anyways, because this is DC and the jury is the DC jury, and you can just extrapolate from all of the other DC cases that we've seen. So if we're in a situation like that, and it probably is going to be a foregone conclusion that you're going to lose the trial, at that point, you basically got nothing to lose. So Dominic Pizzola, in my opinion, decided to sacrifice himself in a way for the other co-defendants of the case, to go out there and to become aggressive with the prosecutor, but to get some evidence out that they have not been able to get out. There's no other way to say the things or get anything admitted into this trial. We've tried, the 5-6 defense attorneys have tried, other than to get Dominic Pizzola to go in there and testify. So his testimony may have shaken a juror or two loose. We don't know. It may have helped to alleviate some of the burden on the other co-defendants. It may have resulted, we'll see, in maybe some exoneration of some of their charges. But simultaneously, it could have been a very risky thing, and maybe some would say an inadvisable thing, for Dominic Pizzola to do that. Because if he is convicted, if they're all convicted of seditious conspiracy, for example, the judge is probably going to sentence him pretty harshly for that disposition on the stand. Because what a judge is going to want to see from somebody is remorse and contrition. And it's going to be hard for Dominic Pizzola, if they are convicted, to turn around at sentencing and then say, Your Honor, I'm sorry, you're right, I shouldn't have done this thing, or I take back what I said, when literally in trial, on the last day of testimony, he was saying the opposite, about socialism, radical socialists. And a lot of the principles that he was talking about, I think, are very valid principles that a lot of Americans agree with. But they were using them in the context of January 6th and twisting and contorting it, talking about, regular phrases and criminalizing all these thoughts about liberty and things like that. And so he is in a position where this could have shaken a juror loose. It could have provided cover for his co-defendants. Remember, when he took the stand, the first thing that he said was, I'm here taking responsibility for my actions. This is what we're doing here. So from that point forward, the whole line of testimony was basically going to be scorched earth. He had to go out and say all of these things. If he would have come out there and just been kind of milquetoast, didn't want to, and there's no new evidence admitted, then it's very likely he's going to be convicted regardless and going to be sentenced probably to a very high penalty regardless. Now, did this put him in a worse position or not? Only time is to be seen. But you can understand how a judge might look at that testimony and say, oh man, I'm going to give you the max because of this. You're not learning, from your mistakes. In fact, you're doubling down on it, and you're calling what's happening in my courtroom a scam and a hoax. Judge is not going to like that. However, in my opinion, the judge has not been given many breaks at all to the defense. So this was a last-ditch effort. It was a Hail Mary. It was a personal sacrifice. It should not be looked over as something other than selfless. He went out there and he's explaining it from his side. He's saying, I'll take full responsibility. And he's trying to exonerate all the other co-defendants who don't have the same opportunity to speak, because we see what the government does in twisting their lives and their records and turning them into monsters, even though they're not. We heard from Dominic Pizzola, former Marine. He is a businessman. He is a husband, a father. He's got a lot of hardship that he suffered as a result of COVID, right? All of these things stand out, but the government is trying to manipulate him and turn him into this conspiratorial insurrection. He decided to get up there and speak out and exonerate all of his co-defendants, and they would not be afforded that same opportunity. They could do it, but it's not advisable to have all the defendants testify because of what the government is doing. So a pretty selfless thing, pretty amazing. We'll see how it goes, but it's an emotional thing to do. On the one hand, you can be rallying behind him and say, man, this is wild that he is, throwing blows at this garbage prosecution, and cheer him on, while at the same time recognizing this is not good for him personally. or it could not be good for him personally. In other words, there's a serious risk to doing what he did. And I didn't want to gloss over that. It was a very, very monumental thing. Okay. A lot of the defense attorneys in that room and a lot of these co-defendants, they're sitting here with all of their hopes on this one testimony, on this one man's, effort to go out there and try to explain this and shake something loose in this trial. So with all of that being said, that long introduction, Judge Kelly is back on the bench. He comes out, he says, "Holy moly. All right, it has been a long trial. It's been a long week." Says, "I don't think we've had a jury in every day of the week, every day. My inclination after reflecting on it," he says, "is to avoid the situation that Mr. Pattis has posed. If only the government is getting its closing in or turning it over to Mr. Smith at 3:30, I think they're talking about, should we do the instructions? Should we do closing arguments? How should we break this down? We definitely don't want the defense or the government to go first and then, a couple days to go by and then the defense comes out." He says, "It's been a long week and I'm worried about the jury losing its focus." And the prosecutor says, "Your Honor, we respectfully disagree. All right. We've worked very hard to get ourselves to this point. There's little doubt in our minds that instructions can be fully presented to the jury in advance of the lunch break, and then we can begin opening statements. The jury's been told we'll be hearing those statements, and I think we've got a jury that's ready to hear the argument. We did give them some intimation that they'd be hearing closing arguments this week." And the judge is saying, "Well, look, if I do this, then I'm going to tell the jury that it's my decision. Okay. You all have worked very hard. We are getting close to closings. The prosecutors want to do closings today." Says, "I'm glad that we're in this position and they have been very attentive. And all that said, I'm concerned about their focus, towards the late afternoon. It's Friday. It's Friday afternoon. Let me go through and knock out things I'm ready to decide. We sent around the revised jury instructions." He says, "There's two things here, and I still have not seen the draft yet." So they're talking about the draft, and I haven't seen it published on the docket yet. But he says he's talking about intent for the assault charges, Donahoe's throwing of a water bottle, and Pizzola's struggle with officers over the shield, talking about the mental state and the destruction of property. Now he's talking about motions to exclude co-conspirator statements. He says, well, there's not adequate proof that a conspiracy exists. Now he's talking about the admission of certain statements. He says, I find that the government has met its burden to admit various statements. That Tario and Biggs joined the conspiracy on 12/19. We're getting dates. That Nordine, Real, Donahoe, Stewart, Wolkin joined the conspiracy on 12/20 when the chat was created. So the chat is the creation of the conspiracy. Good gosh. Bertino joined 12/23 in the chat, and Pizzola joined on January 2nd. So Judge Kelly is also denying a motion to exclude Nicole Miller's testimony to the effect that Enrique Tario created or had some role in the creation of this document. He said, no, it's her subjective judgment. And there was some metadata to support it, so they can think whatever they want. So the judge is just laying blows on the defense. Yeah, admitted for the government, admit various statements, deny a motion from the defense, keeping out this FBI agent, Nicole Miller, who was questionable in her credibility about disclosed documents. Judge Kelly is now ruling on Carmen Hernandez's motion, the one that we just read, to strike the video showing the pepper spray. He says, big surprise here, I'm going to deny that motion. He says the first video was open source and the second and the third video were body-worn cameras. Says the government has a very low bar and they established that Real was in the vicinity. Okay, they just said he was in the area because he recognized this scene and they're implying that that's real, but they can't actually say that that's real. They're just implying it. He says, well, it established that he was dressed in camo hat, goggles, black jacket, and then the government showed him and asked him if you recognize it, and he said, yeah, you could say that. And he did not identify himself. I think a reasonable juror could say that that was him. He could say that a camo hat, a black coat, goggles, gaiter, he could say that that is Zachary Real. He could say that was him. And then there's later footage. Apparently this person is spraying somebody with pepper spray. So he continues. He writes, some analysis applies to the other videos, but there's no reason to believe that these are anything other than they appear. The police body worn camera, says the judge. They even clearly more depict what I think is what appears to be Mr. Real. So it lends credibility to those documents. So all of those videos, they're all staying in. Now, I want to turn to whether there was a discovery violation because Carmen in her motion said that they didn't give the videos over to the defense so that the defense could read them or watch them in this case. He said, well, the specific clips were produced only very recently. The government only found them at the last moment. Wow. So even assuming that any discovery violation occurred, I'm not saying there is, striking the evidence would be draconian. The government produced them within a few days of learning about them. As soon as they got them, they disclosed them to you. And so your motion, Carmen, is denied. And so now we have a dispute about cell phone footage. And the only other issue before jury instructions is about a montage of videos in which a portion comes from Real's cell phone. This is the portion that contains a running transcript. Okay, so this is where they burned this into the video. F them, storm the Capitol. The judge said, my initial reaction before reading the cases was that we need a special instruction, but I don't actually think that's required. He says the words on the screen in the transcript, some cases say the audio has to be intelligible. He said, I was able to listen to it. He says, what the transcript purports to transcribe is clearly the audio passes muster. The judge says, I listened to it. It's good to go. Clearly passes muster. Carmen, you just can't hear. I listened to it. It's clear as day. Transcripts are fine. He says, but the cases says might find that might find if a transcript is sufficiently accurate. I did that. I think it's accurate. And so he says the instruction says, look, jury, you're the fact finder. If you listen to the audio and you don't see what's in this transcript, use only what you hear as what was said. So we're not going to remove the transcript, but we're going to correct it if the jurors hear something different. Rather than just removing it and having a blank slate so that the jurors could come to their own conclusions, they're going to say, if you think your conclusion is different than our preordained conclusion that we would like you to see with our statement on the screen, then you can override our conclusion, right? It'd almost be like saying, hey, we're going to give you this ballot and we're just going to pre-mark who we think you're going to vote for. But if you have a different person you want to vote for, just erase that and then change it. Cool? And you're like, oh, that's kind of weird, but all right. So they're just going to define the terms for you and just tell you what the actual evidence is rather than you listening to it and making your own decision. So he says, I don't see any problem with the transcript coming up the side. However, the other portion of it is about who's the speaker. And the exhibit doesn't say that Zachary Real said it, but it has Real with a circle around him as part of the exhibit. And he's the one that took the video. But I do think when you combine the transcript with his image, it does suggest he's the speaker, which is very much a contested issue in this case, and says, so I think there's a way to resolve this. It's for the government to remove Mr. Real's, the things that indicate it's from Mr. Real's phone. So the government should remove the image, but the transcript is fine. Okay, so this image has to go away, but the transcript is okay. Hernandez says, Your Honor, well, thank you for that partial ruling. I'm glad the image is coming down, but she says, I want more here. The timestamp is also inaccurate on this video. He says, well, that's immaterial. No, it's not. The breach was at 12:54. It makes it appear that he said it was at 12:53. It is material. I mean, that's my position on it. This is the first breach. So it matters what the time is. And second, one of my objections is that you're keeping the transcript up for the whole video. Judge cuts her off. Hey, says Prosecutor Kinnearson already offered to make it disappear after the words are finished being said. Prosecutor gives him a thumbs up, says, yes, Judge, you got it. I'll do that. Hernandez is still arguing about the timestamp. Judge says, I've ruled on that. Sorry, Ms. Hernandez, sit down. She's still arguing. I've heard your objection, Ms. Hernandez. I'm overruling your objection. You're done. She's still going. In a next tweet, she's still arguing. Your Honor, I've said this and it's in my motion. It's clear. There's case law. We put him cited here on page 2. I referenced it. It's another case from the Supreme Court, Your Honor. And he says, listen, Carmen, I have already overruled you on this. I don't know how many times I have to overrule you, okay? Your record is very clear. I've heard you for 5 minutes now. You're still being overruled. Now, the only other thing I want to raise, says the judge, also relates to something Miss Hernandez here, who won't shut up, as raised. Shout out to Carmen Hernandez. We love you. Says, I'm not going to take up the request you've made. We've had multiple charging conferences. She says, Your Honor, this is reversible error if you don't hear this. If you don't listen to my argument on this one, this is reversible error. There's going to be big problems for you. He says, let's hear things that are teed up. He's now discussing two issues that were sent this morning about a First Amendment instruction, which we have not seen yet. There are two pieces to this. He says, I don't know if there's any legal authority to tell the jury what Ms. Hernandez wants me to tell them. She sent in a memo or a request for an instruction in an email. They're talking about jury instructions right now, or about to. And the second piece, is this about whether we did admit statements of Bertino in his podcast? Don't we need to say something like his statements made on January 6th, but they're not admitted as a co-conspirator statements, right? So they're going to give this jury this big packet of rules and instructions that they have to follow. And so they're talking about what to include or not. And the judge is saying, do we have to include something about Bertino? Prosecutor says, my memory is that the instruction given is that the jury could consider those for Bertino's state of mind, but not anyone else's state of mind. So only certain statements are only for certain purposes. And that's because the state of mind of a co-conspirator can be independent evidence of the existence of a conspiracy. I don't think it's accurate to say the jurors can't use statements of Bertino against other defendants. They can be evidence of a conspiracy. And Hernandez says, yeah, but that's the same issue as to Nordine and to Biggs. And the judge says, yeah, but not during the same time frame. The only reason this is an issue is that Bertino's podcast was on the evening of January 6th, after the riot, and therefore not, quote, in furtherance of the conspiracy. So the judge is issuing some rulings. He says, all right, well, I've ticked off all the preliminary issues on my list other than finalizing the jury selection. Got through most of that. Is the rebuttal stipulation worked out and ready to go? He says. Yeah, that's ready to go, says the prosecutor. Defense says, did you rule on the order of closing arguments question, Your Honor? And the prosecutor said, well, our position is that the defense closing should be in the same order as their names appear in the indictment, as we've been using in the questioning of witnesses. Because we had a different... Remember how complicated this case is because we have 5 co-defendants. They are all fighting against the government, being prosecuted by the government. But there might be situations where they want to point fingers at each other to say, no, I didn't do that. You did that, or you did that, or you did this, right? And so there's opportunities for them to call their own witnesses, but then other defendants, co-defendants, to cross-examine that witness or to direct examine that witness. In other words, a co-defendant's witness could be friendly or adverse to another co-defendant. And the question was, who goes first, in what order, who gets to call their witnesses, and how do we present everything? Same question now as the case is coming to a close. Who's going first? Pizzola reasserts all previous objections to the jury instructions. The judge says, look, I'm not going to burn any time on this closing argument stuff right now. We'll deal with that later. Anything else? Pizzola reasserts all previous objections. Prosecutor rolls his head. He's like, oh, gosh. His body language suggests extreme frustration with how slowly this is going. It's Friday. He's tired. He wants to go home too. So Hernandez says, Your Honor, I want to talk about these co-conspirator statements again. And the judge says, sorry, Carmen, no defendant, no one on this planet has cited any authority supporting the instruction that you want. And she says, what are you talking about, Judge? USA versus Tarantino. It's right there. The judge says, okay. Aside from that one, I forgot about Tarantino. You're right, Miss Hernandez. Good call. Nick Smith, representing Ethan Nordine, says there are plenty of other parlor posts between these dates. And it's not correct in the jury instructions, Your Honor, to say that the jury can consider them for, quote, any purpose. I'm not sure a sweeping statement can be made. We got to get more specific. What's the purpose? The prosecutor says, well, as a compromise, I don't think this is required, actually. But if we can carve out the parlor statements and leave it as, quote, essentially telegram and text messages within those dates, we can use those. And he's getting fired up. He says, Your Honor, by the way, I just have to say, it's mind-boggling that we are still working through this at this late date. Hernandez looks at him and says, the court's ruling on statements was like 40 pages. We've been trying to distill it down in a way without making the jury nuts. The judge says, you made these comments literally a few hours ago, right? Minutes ago, hours ago, how long ago? Prosecutor says, Judge, can you give us a 10-minute break? Allow the parties to come up with a way to move this forward. Maybe that would be more productive. Carmen says, I agree with that, Judge. You're making this more difficult. Let us just talk. Says, okay, yeah, that might be right. How long? 10 minutes? The judge says, you'll have 15-minute recess. You guys better get to work. Hash out these instructions. When I come back, you better have some answers for me. 15 minutes. Judge Kelly's back on the bench. We fast forward through time. Prosecutor says, all right, Judge, we're back. I think the parties are in agreement about a couple of things here. First, it's important to get as much done with the jury today as we can. We got to get moving on this, all right? Unlikely we're going to reach an agreement on this instruction today. So what we propose then is that since the court is planning on giving them some instructions after the closings, that you add this to those after we've worked out what to do about this one. But the defense says we oppose going right into closings without breaking for lunch. And we do not want defense counsel to break up closings between today and Monday. Says you're not going to have to break up your closings. Relax. Let's see what we can get done before lunch. But my inclination, says the judge, is to have everyone on equal footing and start closings on Monday. Biggs agrees. Defense attorney's like, yeah, we agree. Nordine agrees. The other defendants don't agree. They're like, we're ready to get started. Now, Hernandez is back. She's asking the judge to make a statement about Freedom and Brian being unavailable. She thinks the jury will wonder about that. She says, Your Honor, I'd love for the jury to hear that we tried to get them and they're not here. The judge says, well, you know what? Juries wonder about a lot of things. Your motion's denied. Metcalf is now asking something, but we can't hear him. And he says, anything else? No, we've got it. All right. Let's bring in the jury. Jury comes walking in. Prosecutor stands up to the podium. He says, all right, ladies and gentlemen, we have a stipulation we'd like to read into the record. We're going to be offering a stipulation, which means this is an agreement between the defense and the government. We don't need to call in a witness. We don't need to bring in any new evidence. We're just going to write it down that we both agree to this thing and save us all a bunch of time. Cool? All right. Jury's like, yeah, thank God. So they place it on the monitor. It says, government and Dominic Pizzola hereby agree that on February 26, 2021, Pizzola was interviewed by agents of the FBI. His first interview with the FBI prepared by counsel. The FBI took notes and prepared a 9-page memo, probably the memo that we didn't get to see yesterday because they redacted 6 of the 9 pages. The FBI memo contains the following sentences. Defense attorneys agree with this. Pizzola stated that his group met up with other Proud Boys at the first barricade at the Capitol. He saw others move the first barricade, but he did not. He proceeded through with the group. Stipulation signed by the prosecutor and the defense lawyer. Stipulation is entered in. The government says, perfect, we're done. We were going to call somebody in to come and talk about that. Now we don't have to. Prosecutor McCullough says, nothing further, Your Honor. The government rests. Sidebar. Okay. Well, ladies and gentlemen, says the judge, you've just heard the conclusion of evidence in this trial. I know it's been a long road. Says now we're going to give you most now of the jury instructions. And then we're going to begin closing arguments. And then on the other side of all the arguments, the government first, each defendant, there's going to be a government rebuttal. And then at close, I'm going to give you some additional instructions. So now the jury is being handed a copy of the instructions. He says, I'm going to give you a big packet here, and you may refer to these as you'd like. You are to consider them as a whole. You may not follow some and not others. If you have questions, you can send me a note. The judge says, my function is to conduct court in a fair manner and instruct you on the law. And it's your duty to accept as I instruct you, and you may not refuse or ignore to follow anything I say. Your function here, ladies and gentlemen, is to determine what the facts are. You are the sole judges of the facts. You alone decide what weight, if any, to give any evidence. You decide the credibility of witnesses. Your recollection of the evidence controls. If any reference by the court or attorney's reference to the evidence does not coincide with yours, it's your memory that controls. Now, you may only consider evidence that was properly admitted, and you should consider any stipulation of fact as undisputed. Throughout this trial, there were statements of counsel. Now, it's very important you understand that statements and arguments of lawyers, they are not evidence. They're only made to assist you in understanding the evidence. And questions directed at lawyers are also not evidence. In any criminal case, ladies and gentlemen, there is what's called the presumption of evidence. And in a criminal trial, it is beyond a reasonable doubt. This burden on the prosecution never shifts. And reasonable doubt in civil cases is only necessary to prove a fact is more likely than not, talking about a much lower standard. In a civil case, more likely than not will find you liable. But in a criminal case, the judge says, like this one, the government's proof must be more powerful, beyond a reasonable doubt. And a reasonable doubt is a doubt based in reason. If you cannot say that you are firmly convinced of the defendant's guilt, then you have a reasonable doubt. A reasonable doubt would cause you to hesitate in the graver matters in your life. But it's not an imaginary doubt. And he's going through paragraph after paragraph, page after page. These are often 40 plus pages. He says, I want to tell you about direct and circumstantial evidence. Let's talk about the difference between the two of them. Assume a person looked out a window and saw that snow had fallen. If he testified that snow is falling, that is direct evidence. He can see it. It's falling in front of his eyes. I have direct knowledge. I'm watching it. Snow had fallen. I saw it. But if he looked out the window and saw no snow, went to sleep, and woke up the next day and there was snow outside, that's called circumstantial evidence. He didn't see the snowfall, but there is snow outside, and we kind of know how snow gets there. It snows. Difference of evidence, important distinction. The law does not favor, he says, one form of evidence over the other between circumstantial and direct. He describes the nature of the charges and says, you must not allow the nature of a charge to affect your verdict. And there's been a number of witnesses here over the last 60 days. And the weight of the evidence is not necessarily determined by the number of witnesses testifying. So just because you heard a bunch of things from a bunch of people doesn't necessarily mean that it compounds. He talks about inadmissible and stricken evidence, tells the jury, you must not hold objections against a lawyer or the party who made them. It's their responsibility to object when they consider evidence to be inadmissible. So if you saw somebody here today that kind of felt like they were annoying you, objection, objection, objection. They have to do that. Don't hold it against them. You're also the sole judges of credibility. You must evaluate credibility free of prejudices or biases. You may consider demeanor and whether a witness had a reason to not tell the truth. Throughout this case, there were witnesses with plea agreements. 2 of them, in fact, he says. We heard about somebody called Matthew Green and Jeremy Bertino. Both of these people did enter into plea agreements with the government, meaning they pled guilty and they agreed to testify truthfully, and the prosecution would consider filing papers that would permit judges to sentence them more leniently. Little bit of acknowledgement that there could be some potential bias here. They're going to say something and they're going to plead guilty and they're going to get a more lenient sentence in exchange for doing that. Now, a plea agreement does not protect them from being prosecuted for perjury, but their testimony should be considered with caution. Police officers or FBI agents, they are held to the same standard of evaluation as any other witness, just because they came out here with their uniform and their badges on. They don't get more credibility. And they say, you heard a couple defendants testify in this case, but several did not. Enrique Tarrio, Nordine, and Biggs, they chose to exercise their right to remain silent. And we cannot hold these decisions against them. Others did testify. Zachary Real and Dominic Pizzola have chosen to exercise their rights to testify. And they should not be disbelieved merely because they are defendants. But you may consider that they have a vital interest in this trial. There was also character evidence presented here. Zachary Real presented 2 character witnesses. They were brought in to vouch for his honesty and integrity. We heard from his wife, I believe. You may give it as much weight as you think it deserves. Evidence of good character alone may create a reasonable doubt. There was expert testimony. Kate Kane came in and talked about telephone extractions, and you can give that the weight you think it deserves. If there were inconsistent prior statements or prior consistent statements, there are rules for those. He says there are transcripts as well as other evidence and exhibits that will be provided to you, furnished for your convenience and guidance. Recording, however, is the evidence of the transcript is not. Recording is the evidence, the transcript is not. If you notice any difference, only rely on the recording, don't read the words. Some of the exhibits that you're going to be looking at were admitted with irrelevant parts, they say, blacked out. Irrelevant. Yeah, right. Our video was played without sounds or sound without video. Then consider only the portion that was admitted. You should not guess as to what was taken out or hold that against anybody. Those redactions are for your own safety. Now, other acts. They say the government presented evidence of violence that occurred in D.C. on November 14, 2020, and some of the defendants' reactions to it. That evidence of the November rally was offered only to prove motive and intent with respect to these charged offenses. So don't hold the violence there against them. You can just think about that as wanting to cause them to form this insurrection, this seditious conspiracy. They got assaulted in November. There were other, so-called violent rallies. And so this was a reaction. They decided to rally the troops, create a chat, take over the country. And they can use that for motive, but not translate any of the violence from that event into this event. Violence and property destruction are offered only to prove their motives and intent here. And you may not use this evidence to infer that the defendants had a predisposition to engage in criminal conduct. Just because it kind of looked criminal back then doesn't mean it's criminal now. You may not convict a defendant simply because you believe he may have done other things, even bad things, that weren't specifically charged. There are multiple defendants here and multiple counts, and so you have to consider, ladies and gentlemen of the jury, separately each offense and return separate verdicts as to each count and each defendant. It says the Proud Boys organization here is not a defendant in this case, and defendants are not on trial for being associated with the Proud Boys. You may not find defendants guilty of a conspiracy merely because they belong to the Proud Boys. They talk about unanimity of the verdict and the proof of state of mind. It says ordinarily cannot be proved directly. No way to know what someone's thinking. You may infer it from surrounding circumstances. You may infer, but do not have to infer, that a person intends the natural or probable consequences of what happened. A defendant's unlawful purpose is not automatically negated because somebody else was there. The judge tells them that an indictment alleges that an offense occurred on or about a certain date. This is sufficient if it's proven that it occurred reasonably near that date, close enough to the dates. And they say that this indictment is merely an accusation, and it may not be considered evidence of guilt. Just because they were charged doesn't mean that they're actually automatically guilty. The indictment contains conspiracy charges and other charges. It alleges that the defendants violated 3 separate conspiracy laws. Let's look at them. And as we talk about trials in all criminal cases here, we often use the idea of checkboxes. And different criminal charges have different checkboxes that must be checked in order for the verdict to be returned guilty. So there are several lists of checkboxes. One is called seditious conspiracy, one of the charges. Made up of these are the 3 different conspiracy charges. Seditious conspiracy to use force to oppose the authority of the United States or to delay the execution of the law. conspiracy to obstruct an official proceeding, and conspiracy to prevent law enforcement officers from discharging their duties. There were several different counts. We know what these counts are: obstruction, civil disorder, destruction of government property, in this case specifically the black metal fence and the window. That's what they're alleging they destroyed. Throwing a water bottle was the assault, and taking a riot shield, right? Throwing a water bottle. And then robbery for stealing the riot shield. These are the charges. So the judge explains that the government must prove several things. Two elements: the existence of a charged conspiracy, so we have to have a conspiracy, and an agreement or an understanding to achieve the conspiracy. Each defendant had to have done it knowingly and become a member of the conspiracy with the intent to achieve the unlawful object, the goal of the conspiracy. And says you must prove each element of the conspiracy. You must show two or more persons, so two or more Proud Boys, either explicitly or implicitly came up with an understanding to accomplish an unlawful objective. This is going to be the big question here. What do they think the unlawful objective is? Was it to obstruct the government? The government is not required to show they sat around the table and entered into a solemn pact. And it also does not have to prove that they met directly and discussed between themselves or all agreed to the specifics. But they must prove a meeting of the minds. The success is irrelevant. Whether they could actually accomplish it or not is irrelevant. And if you conclude that a conspiracy existed and had as the object of the conspiracy the end goal, one of the illegal purposes charged, then you must decide whether they intentionally participated and intended to further it. You don't need to show that all the defendants were fully informed of all the details, just that everyone had enough to know and participate. Duration has no bearing on the defendant's guilt. You can be in a conspiracy for 1 minute. Some played major roles, some played minor roles. No particular act is required. If you're close enough, you're close enough. But you do need something beyond just joining. Mere presence at the scene is not enough. You see this? We're walking a fine line here. Mere presence is not enough, but you don't need a full, conspiracy card before you are joining it. What is necessary is that the defendant join the conspiracy with the intent to aid in the accomplishment of unlawful objectives. If you find the defendant is a member of a conspiracy, you must find that one of the Proud Boys engaged in, advised, or assisted the conspiracy. It's not essential for the government to prove the conspiracy started on any particular date. They say for seditious conspiracy, very similar elements here. You must prove at least one. Otherwise, they're not guilty. Opposing by force the authority of the United States. So in order to check this box, it requires an agreement to commit an act that would adversely affect the ability of the United States to govern or perform its proper functions, to forcibly resist some positive assertion of government authority. This must be a principal purpose and not just an incidental effect of the act. All right. So you can see we're getting through most of the conspiracy stuff here. And these are difficult to read through because it's a lot of law. Let's fast forward through the elements. Here are theories of liability which can apply to the different counts. Ladies and gentlemen, these are so boring. You may find each defendant guilty without finding he personally committed each of the acts. Aiding and abetting, a person may be guilty if he aided and abetted another person in committing an offense, known as an accomplice. If somebody aids and abets, here are 5 checkboxes for them. More elements. They say it's not enough to merely be thinking about it. It's not enough if he made some plans towards committing the crime. We must have clear, undeniable action to commit a crime. Okay. The judge now pauses and excuses the jury. He says, all right, look, where are we? We are where we are. He says, look, the reality is, given the homework you all have to do, this is just another reason why I want to give you the remainder of the afternoon to work on that final instruction. We'll finish instructions and then come back for closings. They come back into court after lunch. Prosecutor says to the judge, they're now talking about dates. Prosecutor says, Your Honor, we request to get the jury in on Monday at 9 a.m. We anticipate that our opening argument is going to take 2.5 hours long. So if we start at 10 a.m., the government's open will be broken up with 2 breaks. He says, all right, let's try 9 a.m. They bring the jury back in. The judge says, Mr. Pattis, if you'd like to go out of order on your closing, you may. Otherwise, it's going to be the same order as the indictment. Saying that maybe Pattis. Anyways, so the jury comes back in. He says, all right, ladies and gentlemen, I know I promised closing arguments today, but they're going to be lengthy. So I think it better not to break that up with the weekend. You've been here every day this week. We've rarely sat Friday afternoons. We'll just have you come in on Monday at 9 a.m. and begin. Soon as we're done here, we'll let you go. So here are the elements of corruption or obstruction of an official proceeding. Attempted to or did obstruct a proceeding. Acted knowingly, acting corruptly. Defining corruptly. Corruptly means that you must use an independently unlawful means or an act with an unlawful purpose or both. More elements, which we'll fast forward through. Now, here's a self-defense argument. Dominic Pizzola has argued he acted in self-defense. If this is going to be applicable, the jury must find that the exercise of force by law enforcement was unlawful and excessive. The jury must say that Dominic Pizzola may use an amount of reasonable force that was necessary to protect himself if he was in imminent danger from bodily harm. The elements of robbery: took the property against the person's will by force, carried the property away, and took the property with an intent to permanently deprive. 6, property belonging to the United States, and the judge finally closes it out. He says, all right, whew. All right, those are your initial instructions, ladies and gentlemen of the jury. There will be some shorter additional instructions after closing arguments. We're going to excuse you for the weekends. Now, reminder, we're at the very end of this thing, so don't talk to anybody about this case. Holy moly. Jurors file out of the courtroom. The judge asks the prosecutor, hey, Mr. Kinnearson, any word from the group? Your Honor, we recommend 5 p.m. on Saturday as a deadline for us. That may give you some time to respond. He says, that's great. 5 p.m. on Saturday is a good deadline. Everybody, great job this week. Have a good weekend. We'll see you right back here on Monday. And so that, my friends, is it for the day. So we are mostly done with jury instructions. We are done with all the testimony. Both sides have rested. Closing arguments will start bright and early on Monday morning at 9 a.m. And of course, we will cover that day and all of the closing arguments here. Thank you for subscribing and liking this video wherever it is you are watching. We look forward to seeing you on that one. Now, this, my friends, is what we covered. We covered some good ground today. Trial day 60, 2 motions to strike. We saw some new updates with Ray Epps, some new troubling video. We're very familiar with all of the historical background on this guy and why people have questions. Don't think it's a conspiracy theory at all. There's a lot of facts to talk about. And so now, my friends, after all of that, it is time to hear from you and to see what you have to say about all of this. From our amazing friends on YouTube, our friends over on Rumble, on Twitter, and of course, our members on Locals, which is where we will be going for our after party. Stumbling all over myself here today. It's a Friday. Here, let's see who is in the house today. We had a couple super chats come in. Woo, baby. Who do we have? Dapper Dave. He says, I saw Ashley Babbitt video where she got shot. My question is, what happened to the 2 or 3 other people who were breaking down and smashing the doors? Should be the poster boys for J6 by the media. Was it Antifa? Gosh, I don't know about that. Dapper Dave, I think it would be well worth an investigation. Wouldn't it be nice if we could see all of these body camera footage recordings so that we could start to assemble the full picture and see what was going on and identify these people? And I would love to also hear from the DOJ. Did they investigate Antifa? How many people of Antifa did they investigate? Was there any arrests for that? Did they even look into it? I doubt it. Thanks for the great comment, Dapper Dave. Maybe one day we'll know. Tony, hey, Munkits is here. He says, I'm sure, but most people here know this trial is screwed, but we go by the system to seek the truth. Having you to explain what's going on is a great help. Thank you. From Tony Hay Munkits. Thank you, Tony Hay. Yeah, says a lot of people know this trial is pretty messed up, but we are going through it together, man. And Tony, I appreciate that, you sending that in. I agree with you that a lot of people, are missing this, unfortunately. And that's by design. The courts make it hard to make this stuff accessible. And so we appreciate you being here and joining us as we cover it. Hey, Fred Pedamonte's here. Now, Fred Pedamonte and Johnny, it was Johnny's birthday yesterday, and so shout out to Johnny. But he says, Rob, I joined the Proud Boys, not the Pride Boys, which I thought it was the Pride Boys. I mean, we had that come in yesterday. I'm pretty sure it's on the record here. Where do we see this one? Yeah. Johnny also joined the Pride Boys. That was yesterday. I thought you said Pride. I thought that's a little bit strange. Is Johnny what? So he's correcting the record. No, it was the Proud Boys, not the Pride Boys. And I said, I'm familiar with what goes on at the Proud Boys. I don't know what was going on at the Pride Boys or whatever that is. That doesn't sound as patriotic. It sounds, different. But so anyways, that's good. That's good to hear, Fred. Thanks for the correction. And Michael Allen Hughes says, can a 60 Minutes interview be used in closing arguments? I mean, no, I don't think the judge would allow it in, but I don't think it'd be really useful. I mean, maybe they could say, we wanted to subpoena Ray Epps. He didn't come in here and testify, but he's showing up on 60 Minutes. You get an objection. None of that was in evidence. And yeah, I understand what you're trying to do. We'll see. Maybe they'll use it. I don't know. We'll see. But that, my friends, is what came in over on YouTube. And thank you, everybody on YouTube. And I saw another one come in from Alan Harkin. What's up, Alan? Alan Harkin's on the YouTubes. He says, great show. You bring clarity to confusing aspects of the trial. Well, thanks, Alan. And thanks for being over here. I think normally you're on Rumble, no? It's good to see you on YouTube. Crossing the streams. I appreciate you being here and sending in the lovely, lovely chat. Look, I'm glad that you guys are here and that there's interest in this trial. It's a very interesting trial. I think it's monumentally important. And I'm grateful that we're here to go through it together. It is a ton of fun. And so, all right. And so that came in over on YouTube. Let's say hello to our Rumble friends and see who's in the Rumble house. Who's over there today? We got Vienti Kiss. We got Janex in the house. We got Sedona Rocks. Let's see who else is over there. We're doing some refreshes on the screen. There we go. Fairy Dance. We got Slightly Salty over there. It's good to see Seth in the house. A big thumbs up. Rob, you're great, but you just can't compete with Trump, says Judy. Pfft. Well, it's true. My hair is not even close, huh? Not even close. Not even close. That came in from Judy. Yeah, it's true. I'm not trying to compete with Trump. That'd be a tall order. You see what he does to other people who are running for president. And what a job that would be. All right. And so those came over from Rumble. Let's say hello to Twitter and to locals. And of course, if you're a YouTube member, and we just had some amazing new YouTube members come in today, courtesy of Dolphin Fan and Voice of the People. Grateful for you inviting some new people to come in. And let's go over to Twitter before we check in with locals and go to our after party. We've got 16 viewers on Twitter. Oh my gosh, it's a Friday. It's a Friday miracle. How did that happen? Anytime we're in double digits, it's like, man, something's broken or something. Hey, Julie Kelly's here. Hey, it's Julie Kelly. Hey, Julie Kelly says, running out of words for this. Oh gosh, indeed, isn't it? It's just indeed. Indeed. Shout out to Julie Kelly. We love Julie Kelly here, man. Julie Kelly, if you're not following Julie Kelly, you should be. She has been on this and she is so plugged in. It's just amazing. We love Julie Kelly. Julie, we love you. Keep up the great work out there. And yeah, it is. Yeah. What else can you say? We're coming to a close. All right. We also had James Pepper, who's in the house. Two birds, one stone. Says this has all the telltale signs. I don't know what that is. So it looks like, I don't know what that, you're going to have to go over to Twitter to figure out what that was all about. There's something in the ground that I didn't understand what that was. James Pepper says they're blaming Donald Trump. We got Danny McWilliams is in the house. And we got a new ruling. Oh, from the Supreme Court just came out. Ooh, well, we're going to have to hit that tomorrow. We'll hit that tomorrow morning on our members only stream. Supreme Court. Yeah, Friday night deadline, right? Tonight. And here, Supersonic Station says, getting out the popcorn for this one. Going to be an interesting day in court. Keep up the great work, Rob. Rob, the lawyer of the land. Thank you, Supersonic. And we had a couple other comments. Here, this one came in from Transform. Says, in case of a guilty verdict, how would Judge Kelly's rulings affect the appeals process? Well, I think any one of those there are several rulings there that I think would be appealable. And the question is, whether that could change the trial, in other words, change the outcome of a trial. So, for example, well, we even heard Carmen Hernandez bring up today, reversible error to not do things a certain way. She's fine. All of these motions to strike are all laying the foundation for an appeal. Depending on what the verdict is, there's going to be a whole slew of secondary motions coming out. Hopefully, it's just an acquittal. Let's be realistic here. Here, Korean says, this Judge Kelly was on the prosecution side from the beginning. Otherwise, he'll pretend otherwise to assuage his own conscience, says Korean in the house. Good to see you on Twitter. And another one from Danny McWilliams says, they are in D.C. The only jury instructions are, once you find them guilty, let's go for a beer. We all know it's kind of a joke out there from Danny McWilliams. And James Pepper's over there. And so shout out to all of our Twitter friends. And Julie Kelly over on Twitter saying hello. And so, all right, my friends, we are going to leave it there. Oh, we had some tips over on locals. Well, that's cool. Okay, so Jay Cutbirth says, well, that's really nice. All right, we'll save that for the after party. And GSD says, those guys were Antifa. They immediately vanished into the crowd, going down the stairs, changed their clothes while making their getaway. There's a video breakdown on this by Crossroads by Joshua Phillips. Joshua Phillips is also great. I like his content a lot too. He posts good stuff over there. He's on the Epoch Times, right? Over at the Epoch Times. So a lot of brilliant people out there doing good work on this stuff. And so make sure you're giving them follows and supporting all their work out there. But Jay Cutbirth says he got a shout out on LinkedIn. So thank you, Jay Cutbirth, for that message. But all right, so we are going to go over to the after party. We had another one come in from Carl on YouTube. What's up, Carl? Thanks for sending that one in. Let me grab this one. Here, this one came in, says, I still think the Proud Boy defense should have been why they want to stop the GOP from contesting the Electoral College vote. Should have been, why would they want to stop the GOP from contesting the vote? Arizona objected to the House, and the House roared in approval. We had momentum. That's a great point there, Carl. Yeah, that the point being is that, right before all of this broke down, there was a debate over this, right? Didn't Senator Ted Cruz object? And he had a counter proposal where they were going to go into another room and count the things, and then it all sort of came crashing down. But it is a good point. They didn't want to interfere with anything. Or why would they want to interfere with anything if they were just going to count the votes and they were going to go do this, I forget what the plan. There was a plan. There was some sort of a plan to object and to count and to break into a special session or something like that. And then it all got thrown off the rails. Maybe by design, because they didn't want a special session. They didn't want anybody to investigate it. As soon as there was this insurrection, nobody even thought about it anymore. There was no discussion about anything anymore. They raced everybody back in there. They said they would, vote, 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 vote. They got the vote done that night. No investigation, no further inquiry, no second round of question.